All right, council, did you make the copies of the motion?
Yes, Your Honor, I gave them to the state. Oh, I'm sorry, your copy.
Yes.
Or your file stamp. Yes.
Thank you very much.
Wow.
All right, we're ready. All right. Oh, you can read the jury out there. Court is calling 2022 CR 10756, State of Texas versus Marcelino Scott. Do I have parties announced for the state?
Ruben Herrera and Brittany Mitchell for the state.
For the defense?
Jessica Gonzalez
And Tracy Franklin.
for Mr. Scott.
All right. And my understanding, the defense has filed a motion.
Yes, Your Honor, I filed two motions. The first one I'd like to address with the court is going to be my motion to dismiss for lack of due diligence and violation of constitutional rights.
All right. You may begin.
Thank you, Your Honor. The first thing I'd like or ask the court to do is go ahead and take judicial notice of the date that I went ahead and cited in my motion. My client was arrested, according to the public record system, my client was arrested on June 28, 2022 for a crime that allegedly occurred on June 27th and then June 20th of 2022. There are several dates that I've cited in here of when he's demanded his right to speedy trial on January 9th, 2023. At one of his trial settings, he was ordered to be dressed and ready for trial on February 7th, 2023 trial setting. There was another trial setting I put on here February 1st, but I'm sorry, that should be February 14th for what he was scheduled for. And then his trial setting was reset to this current trial setting, April 11th, 2023.
And counsel, just so the record can be noted, the trial date for, I believe it's January 13th, the court was in jury trial.
Okay, thank you, Your Honor. My client will be, we've talked to him this morning, he will be prepared to testify to some of this information and the times that he came back for court. The defendant appeared in court on April 11th for this current trial setting with trial counsel, and we all announced ready for trial. The court ordered all parties to return on April 12th in order to select a jury. Before jury selection, we all signed a discovery acknowledgement and we presented that to the court, and I believe the court signed it on that day. And then from there, we did do jury selection where we selected a jury of 12 people and one alternate that was seated at 2 p.m. At that time, the court excused all parties for the day. We recessed for the day because of a personal emergency with the defense counsel. However, we did all leave the courtroom early enough in the afternoon. What happened from there is, and this is the crux of my motion, is at 9:54 last night, I received an email which I attached as an exhibit, and I also have a clean copy that I can also tender to the court and introduce into evidence if the one that's on the motion is not sufficient. However, I received this email at 9:54 last night from the lead prosecutor, Mr. Herrera. This email also contained about, I think it was a total of 5 pages, but when you put everything together, I think it comes out to about 4.5 pages of typed notations, notes that he took in speaking to the complaining witness in this case, and one of the other witnesses that he did express to me that he does plan to call as a witness to one of the offenses.
And which is this witness he's planning to call?
I believe her name
Allegedly.
is Destiny,
Okay.
and then the complaining witness is going to be Ashley Myers. So this email was sent to me after the jury was selected, which is a very big point for my motion, but also less than 24 hours since testimony was set to begin. Now, with that being said, in doing this, the district attorney's office has thrown my client into what I coined at 2 a.m. this morning as I'm going through all of this information as the Bermuda Triangle of where his constitutional rights are being violated. In this motion, I identified 3 specific constitutional rights that are being implicated with what the prosecutor did with that email and that late party disclosure notice. He has violated my client's constitutional right in order to prepare for trial by giving us this information. He's given this information after we have already selected a jury. After my client has already made the decision to reject any plea offers. Therefore, his decision to proceed to trial is no longer intelligently and knowingly made. He's also violated my client's constitutional right to confront the witnesses. As we go through this motion and we start looking at the possible remedies that are available to the court, one of the remedies is to be able to exclude the information that was provided in this notice. However, by doing that, he is now preventing us from effectively cross-examining a witness. So therefore, the prosecutor violated my client's constitutional right to fully confront the witnesses. And then lastly, he has violated my client's constitutional right to a speedy trial. I do know that we are now within 1 year of the offense date. However, my client demanded a speedy trial, and that's what he was getting. This court was providing to my client that speedy trial he asked for. Yet, by doing this, we're now having to look at another delay in this case because of this tardy disclosure. Everything that we're looking at right now, and I'm asking the court to consider, is because of the state's failure to get this information to me and to my client anytime before less than 24 hours before we're start to set testimony. The Texas Code of Criminal Procedure imposes a duty on the prosecutors to turn over discovery in their possession of the state as soon as practical. Now, in the email that I did provide to the court from Mr. Herrera, he did state in there that he had just spoken to these witnesses that afternoon. And I completely understand that. However, under State versus Heath, that court in Waco, the Court of Appeals, has gone ahead and extended that as soon as practical date to putting an additional duty on the prosecutors to go out and affirmatively get this information, not just as soon as practical, and not just when they're ready to prepare for trial, but getting it to the defendant in order to preserve his constitutional rights to prepare. Now, in doing this, as I stated, we're now left in a situation that the only proper remedy for my client and to cure all of these infringements is going to be for a dismissal. As I explained, if you exclude the evidence, you're violating his right to the state has violated my client's constitutional right to confront the witnesses. If you give us a continuance, then we're now violating his constitutional right to a speedy trial. Furthermore, my client has not had sufficient time in order to go through this document that was provided to us at 9:54 last night. With that being said, Your Honor, I'd like to call my client as a witness to lay further information for the court to consider.
All right, you can call your client.
Mr. Scott, and Your Honor, just for the record, this is just for the limited purposes of this hearing.
All right, Mr. Scott, if you'll take a seat. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
MARCELLENO Scott.
All right, defense.
Mr. Scott, have you requested a trial in this offense?
Yes.
And did you do that because you're wanting a trial to be able to share your side of the story of what happened?
Yes.
Are you currently employed?
Yes.
Where are you currently employed?
Charter Communications.
Okay. And are you having to take time off of work in order to come here for these court appearances?
Yes.
Do you remember how many times you've come in for trial?
The reset dates or the amount of dates?
All of the dates, sir, that you remember.
I think it's been 4 times that I've come in for an extended period of time.
Okay. And when you say an extended period of time, what do you mean by that?
I would, for example, it came in for trial January 6th, maybe, and it was a Monday, but it kept getting reset because of different trial dockets. So I had to keep coming back every day that week.
Okay, so when you say reset, do you actually mean recalled, like you were told to come back the next day?
Correct.
Okay, and each one of those times, did you have to take off of work?
Yes.
Has doing that the multiple times put your job in jeopardy? Even though you have the job right now, is it causing tension at work?
Yes.
When was the first time you saw the document with the additional statements of the complaining witness?
This afternoon when I came in,
Okay.
approximately 1 o'clock.
Okay. Have you had sufficient time to go through that document line by line with me?
No.
Is there information that you've reviewed in that document that you would like to get evidence for to oppose it?
Yes.
Okay. Will that take additional time to be able to get?
Yes.
Did you already take off in order to to be here for the trial that we're doing right now, going forward, to go continue with testimony.
Yes.
And I'll pass the witness.
State.
Mr. Scott, have you been told by your employer that your job is in jeopardy?
Yes,
How's that?
because I started on October 20th and you can't miss any work for the first 12 weeks. And then since the time in January, I've missed time a lot because of coming to court. And they were asking me, why am I missing so much time?
But have they told you that you're
Yes, because
imminent to be fired?
yes, attendance adherence would cause you to get corrective actions that could lead up to termination. And I already was under the probationary still.
But have you been specifically told that you will be fired?
Yes,
And what time approximately was the first time you saw the document that the state tendered to your defense counsel?
it was 1:30, like today I came in.
Okay. And Mr. Scott, you were booked for these charges on June 28th of 2022. Is that correct?
I'm assuming correct, because I was arrested on June 27th.
And when you were hired in October for your current job, did you let your employers know that you would be having court proceedings at the time that you were hired?
No.
Okay.
I did not know about it. Till after.
And Mr. Scott, at this point, have you read the disclosures that the state provided to your defense counsel?
Briefly, yes.
But you haven't read the whole document?
No.
And Mr. Scott, when were you told that these disclosures were made to your attorneys?
When I'm ordered in my press conference room at about 1:30-ish.
Were you notified by your attorneys prior to that the state had made these disclosures? Had they attempted to contact you at any time this morning to discuss those disclosures?
Not that I know of.
Were you aware that your attorneys were going to be filing this motion to dismiss this
No,
afternoon?
no.
Nothing further, Your Honor.
All right, anything else?
No further questions of this witness, just continued argument.
All right, you may step down. All right. Court will hear brief argument.
Yes, Your Honor, the thing that I would like to end with is specifically talking about this defendant's time to prepare, the constitutional right. The Sixth Amendment to the Constitution specifically says the assistance of an attorney. The case opinions that came out after that have coined it as the time to prepare. I think what the prosecutors were just trying to get at is just simply by Mr. Scott or them having notified us of these statements and that this was done, that fulfills their obligation and that now satisfies the defendant's time to prepare. And that's just simply untrue. Your Honor, when we're looking at time to prepare, we're not just talking about looking at a statement and reading the information and absorbing it. You're talking about tracking down the additional witnesses that are listed in these statements. You're talking about investigating that background. You're talking about subpoenaing people, looking for witnesses that are going to go against and contrary to what that new information is. Time to prepare is exactly what a person is guaranteed by the Constitution and what we're looking at. The state of Texas has violated the client's right and the time to prepare, along with the speedy trial and along with the his right to confront the witnesses. any other cure other than a dismissal is going to infringe one of the other rights. That's why I coined it the Bermuda Triangle. That is why I am asking for a motion to dismiss. That is the only way for us to be able to fix the situation that the state of Texas has put my client and myself in by providing this disclosure. Under Heath, again, they have the duty to do this sooner. They can't just rely on the fact of they decided to prepare for the trial at the day after jury selection. It's after jury selection that they spoke to this witness. They've had the past 9 months, 10 months to be able to speak to the witness to get that information, but they chose after jury selection. That means they're assuming the risk that if those witnesses give them additional information that they have to tender, they are now taking on the responsibility of possibly having a case dismissed because of their fault of not doing this in a timely manner. That is why I'm asking for the court to grant this motion to dismiss. Thank you.
State.
Your Honor, for the state's first argument, Your Honor, as counsel has noted in their motion to dismiss, we did tender these disclosures to counsel at 9:54 p.m. As this court is aware, we were in court selecting the jury for this case, anticipating a proceeding at one point. And as is noted in the motion, the parties were in the courtroom until approximately 2:00 p.m. It was at that time that we went to our offices to prepare for trial with the complaining witness and her daughter, who's another witness that the state's anticipating in calling to testify. That meeting, Your Honor, went on until approximately 5:00 p.m. And those notes, as is customary of our office, are taken by our victim's advocate in shorthand, as there's a lot of information that is presented. And so in addition to having that meeting, it was my responsibility to annotate those so they would be legible to counsel. Those were tendered again at 9:54 p.m., which was the earliest that the state had the ability to provide those to counsel. As the defendant testified on the stand, he was unaware until 1:30 p.m. when the state and defense were to be in the courtroom prepared for trial of these disclosures. And I understand counsel's position where they may have other cases to prepare for on the day, but the state has the same burden, Your Honor. Counsel could have met with the defendant at any point up until 1:30 to discuss the disclosures and discuss any of the information that was presented in order to determine if any evidence would need to be obtained in order to defend themselves against any allegations or disclosures that were made against
All
the
right, here's my
defendant.
question.
Yes, Your Honor.
I've read through defense counsel's motion. The recitations, I guess that's by Ashley, I'm sorry. The additional statements. Are any of these additional statements that are listed in your notice to the defense, are those in other places in police reports or in other statements?
A majority are, Your Honor, listed in police reports in police reports for these incidents that are alleged in the indictment, as well as reports that were tendered to counsel regarding previous incidents involving the defendant and the complaining witness.
All right.
There is other information that the state was unaware of up until yesterday, and that was not listed in prior reports as well, Your Honor.
All right, and which part of defense's motion, I'm sorry, of notice to the defense was not in prior police reports or prior statements? And let's start on the page beginning with notice of additional statements.
Your Honor, defense counsel was provided with documents regarding the protective order. So that information should have been included in subsection A or subsection 1.
Is there anything on that page that was not previously tendered to the defense in the form of a police report or a statement from anyone?
Your Honor, In regards to all of the disclosures that were tendered, there is a mix of statements that were made as well as additional information that was given to us by the complaining witness surrounding the allegations.
Oh, but what I want to know is there anything on that page that was not previously tendered to the defense in the form of a statement that they've had access to or something that's in the police report? So this is what I want from each party.
Yes, sir.
I want you all to confer right now, and I want somebody to highlight that portion of the additional notice of additional statements. I want that highlighted on what the defense did not know about.
And Your Honor, if I may, that's kind of what goes to the crux of part of my argument of.
Here's the thing, I want you guys to do that, then I'll hear the other argument, but I want that done now.
Well, what I'm saying is there's multiple statements, multiple statements.
Yeah.
Okay.
All right, and are we ready on Mr. Hagee's? Where's Mr. Hagee? Does anybody need a highlighter?
I have some.
Oh, here, please do yellow, yellow for some,
I think.
okay, yellow yellow is easier for me to see for some reason.
I think I have yellow, yeah.
Do you want us to?
Oh, do you have,
Well,
you have
let's
yellow?
look, yeah.
You want one?
If y'all want to make a copy of that and then highlight which one.
This is my copy.
All right.
Why don't we go through, we'll highlight what we think and then I'll highlight one. I don't know.
I guess we can do that. Or we can go.
Oh, the,
Oh, sorry.
If y'all want to go back
To the other side.
to the chambers, or
Chambers? Okay. Do that.
I think there's some extra seating in.
You say. Well, can you, not to chambers, but can you go back to office?
Yes, I mean, is it okay? Yes, you can go back into the office. And that's what I say when I mean chambers, to the office. No. All right, and Mr. Hagee, what is your client's name?
Mark Cross?
All right. All right, what is happening with this case? Are you all ready to proceed?
I think we're very close. Judge, I was just pulling up. Full disclosure to the court. There is a mag that is being with the defendant. I was just trying to see if there's any restitution amount that was in the police reports. I was just pulling it up. right
Okay, if you all continue to look because this is taking a while.
Okay.
All right. And can you let the jurors know that we're probably going to start at 3? And you can meet us. Well, hopefully we'll start the jury today by 3. We shall see.
You're gonna have to hear music, Judge.
Yes, I do. It's going. I could be wrong, though. We shall see. Oh, are you guys ready on Mr. Cox?
We're very close, Your Honor.
Yes, Judge, I think we're ready.
We're ready.
Okay. All right. Court is calling 2021 CR 4964 and 2018 CR 11550, State of Texas versus Michael Cox. Could I have parties announced for the record for the state
Daniel Escobar for the state of Texas.
defense?
Mr. Cox.
And are you Mr. Cox?
Yes, ma'am. Bless you, Judge. Bless you.
Sorry, thank you. It's not cold in here, so we're not gonna have the temperature adjusted.
Mhm.
All right, and are you Mr. Cox? Are both parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, Mr. Cox. In each of the cause numbers, I'm showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them? And did you understand them?
Yes.
Okay. Are you the same Michael H. Cox II, who was placed on deferred adjudication in 2021 CR 4964 for the offense of is there any motions from the state with regards to that motion? The offense isn't listed. It just says for the offense of 30,000, 150,000.
Your Honor, just an oral motion to amend the MTR really quickly, just to add the word theft.
Any objection? All right. Are you the same Michael H. Cox II, who was placed on deferred adjudication in 2021 CR 4964 for the offense of theft, $30,000, $150,000 on December 6, 2021 for a period of 4 years? Is that you? And are you the same Michael H. Cox II, who was placed on deferred adjudication in 2018 CR 11550 for the offense of theft, $2,500 to $30,000 on January 14, 2020 for a period of 3 years? Is that you?
Yes, ma'am.
Right. State, are you proceeding on the same allegation in each motion?
Yes, Judge, but in one motion, it's listed as violated condition number 15, and then in the other, it says violated condition number 16.
All right, then if you will read the motion in each case separately. So
Sure.
we'll proceed with cause number 2021 CR 4964.
Violated condition number 15, on or about the 26th day of April 2022 in Bexar County, Texas, the defendant, Michael H. Cox II, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 15.
How do you plead to that? True or not true?
And Judge, in
Do you waive all of the allegations?
yes, the state waives all their allegations.
All right, did you understand by pleading true to violation of condition number 15? The court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 15?
Yes.
All right, the court will find violation of condition number 15 true. And in cause number 2018 CR 11550 state.
Violated condition number 16, on or about the 26th day of April 2022 in Bexar County, Texas, the defendant, Michael H. Cox II did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 16.
All right, how do you plead to that, true or not true?
And Your Honor, state waives all their violations.
Any objections?
No objections.
Did you understand by pleading true to violation of condition number 16, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 16?
Yes.
Court will find violation of condition number 16 true. Is there an agreement in each of these motions?
Yes, Your Honor, there is an agreement. There is one difference in both case, in one of the cases from the other.
Okay,
So in 2021 CR 4964, the defendant, we're just asking for the defendant to be continued on probation with the condition of a theft class level 2, and to alternate amend to report for twice, to have to report twice monthly for 60 days. And in addition, we're going to add it's $6,120 in restitution to Eric Guetta.
is that ERIC?
Here, give me 1 second, Judge. I have it spelled out on my computer. It's ERICK.
Okay,
Guetta, GUERRA. And the state is going to take into consideration cause number, it's CM 105222.
all right. And then, and cause number ending in 11550.
Judge, he's gonna be continuing on probation. He's gonna have to be extended because it did expire back in January. We're extending him to March of 2024. So it's gonna be about
We just said one.
it's a 1-year extension. Oh, sorry, then January of 2024. I apologize. And he's just gonna have to do a condition or a theft class level 2 and report twice monthly for 60 days.
Is that the agreement?
Yes, Your Honor.
All right, Mr. Cox, why shouldn't I send you to prison? Why are you not reporting? To do your UAs?
I believe at that time, Your Honor, I was sick.
Okay,
I had health issues last year.
all right, what health issues?
I- COVID, had stroke, found out I had brain tumor. So, no excuse though.
Okay.
I should have been going and
Why didn't you pick up the phone and call probation? Did you tell them about these issues?
with Officer Smith.
Ms. Abrams, did he inform his probation officer of his health issues?
Your Honor, I would have to review case, just in one moment.
Yes,
What time frame are we looking at?
from the time he was not doing anything. So he pled to a violation of 16 and 15.
Yes, Your Honor, it'll take me just a moment. please.
If you're drug tested today, what are the results gonna be?
Negative.
All right, we're gonna do a UA today. And I do not want to see any further theft. Do you understand? If it's gonna be, if it's something that's predates your time on probation, then I understand maybe something was missed when the plea deal was made. But there better not be any other thefts that postdates the time that I put you on probation. Do you understand?
Your Honor, it appears that in March of 2022, there was an office visit. Looks like in April of 2022. He did let the CSO know that he had COVID. He got COVID in January. Then there was a failed visit attempt. in May, but there was no response from the attempt. There was a manager hearing. And Mr. Cox was counseled in May of 2022. And again in June. But it appears over those during that time that there was communication. July, there was an office visit in 2022. The only thing that I see notated about is medical. Is the COVID. I'm looking at our documents that are scanned and I don't see anything, you know, medical, like proof or anything provided.
All right, thank you. All right, and cause number 2018 CR 11550. Court will deny the motion alternate amend conditions to extend for 1 year. Theft course level 2. This run concurrent with 2021 CR 4964. There's to be a UA today. If it's positive, then there's going to be weekly reporting for 60 days. If it's not positive, then it'll be a regular reporting. And cause number 2021 CR 4964. Court will deny the motion, take in consideration CM number 105222. There's to be theft course level 2, $6,120 restitution to Eric Guerra. There's to be a UA today. And also the defendant is to provide medical documentation. You said it was a brain tumor?
Yes, ma'am, I was diagnosed August.
All right, you need to provide medical proof of that by May 1st. If he's positive or does not provide medical proof by May 1st, then it's to be weekly reporting for 60 days. If he does provide proof or test negative, then it'll be regular reporting. Is there anything else from either side?
No, Judge.
All right,
Thanks, Your Honor.
thank you.
Thank you.
You're welcome. Hello. Yes.
Interesting, council office,
Yes.
received a call that y'all wanted us to check in on, some inquiries, please.
Yes, she's here. The attorney, for some reason, is not located in San Antonio. And it's been difficult to get in touch with that attorney. And the court coordinator is telling me that this was specially set for that attorney for this day.
Okay, I know that this is a name that we've run across in our office regarding availability and issues with that. So I'll speak with the client, try to get a gauge on, you know, what her communication level is with her attorney. I know that I looked a little bit before I came. I believe that the attorney's been on the case since October. So I'm gonna try to just take a moment and get a feel for what's going
Sure.
on.
Just 1 second. Can I see the file on Celine? I think it's Celine Breer.
And did the attorney call today and say that she wouldn't, just no call?
She was supposed to be here on Monday. I called her. She said she had stuff to do in Hughes County. She wasn't able to meet on time. I asked her, well, can you come in on Tuesday, she said no, she said Thursday would work better for me, I set it for Thursday. And she's fine.
Okay, and no contact either
I
way.
emailed her and I called her
Mhm.
or text her, I sent her a text.
Yes.
Yeah, that's what is here. Recall, attorney in Houston.
Okay. So the note was, it was recalled today because she was in Houston.
Yes.
I want to have my office try to contact her. I'll speak with the client. Hopefully with a resolution.
All right, thank you.
Thank you so much.
All right, and I'm gonna, can somebody see where they are in the back, if they're done? With going through that, yes,
The UA positive, if so, would be reporting for 60 days, is that, on both cases or just, one?
oh, that's on both cases. Mhm.
Lisa, we're still going through it line by line.
Oh, yeah, I know that.
You want me to tell them to come back here?
Yes. All right, so we're back on the record in 2022 CR 10756. All right, with regards to defense's motion to dismiss, that will be denied. With regards to the what's tabled, notice of additional statements that are being submitted to the defense. If these are not statements that are in a police report, if these are not statements that have been tendered to defense counsel before, then it will be excluded. With regards to the witness who's mentioned here, and I believe that's the daughter. If that information with regards to the daughter, if that's not in a police report, if that has not been tendered before, then that will be excluded. Is there anything else with regards to the motion?
I think your orders are clear. However, there's a few, I think defense and I might disagree on what suffices as mentions. Because there are indications in like the 2089, she talks about, she just wrote choking Beaumont with a date. But obviously she didn't go into detail about the Beaumont, which she did with us yesterday. So I think we might have a disagreement as to what qualifies as something that they had notice of. Like with regards to that, I guess.
All right, you all can make your objections when the witness testifies. Before you go into that state, you'll need to approach.
Yes, Your Honor.
With regards to, I believe it's the daughter that's mentioned in one of these statements. Again, if that is something that is not in a police report that has been given to the defense, or some statement that has previously been given to the defense, it will be excluded. With regards to this daughter that's mentioned, is this daughter going to be testifying?
The additional,
Destiny,
Destiny will be testifying. Your Honor,
All
yes.
right, and defense, have you been given information on Destiny prior today?
I've known about Destiny, but her statements that she gave to the prosecutors yesterday differ and provide additional details. And even when she spoke to the prosecutors yesterday, she even admitted that she did not provide this information to the police officers.
And Your Honor, the witness Destiny did provide a statement to officers at the time of the incident, so we believe that it'd be proper for cross-examination, but not to exclude.
Well, anything in the additional statements that have been given to defense, if the defense did not have them before today, it is excluded. All right, anything else with regards to the motion to dismiss?
Not for the motion to dismiss. I have the motion for continuance on file also, Your Honor.
All right, the court will hear your motion for continuance.
Yes, Your Honor. I filed a motion for continuance in anticipation that if the court were to deny my motion to dismiss for the constitutional violations, the next step would be for me to ask for a continuance in order for my client to prepare. As he previously stated in the other hearing that we did, we have not had sufficient time to go through this line by line with him and for him to be able to give us the information to contradict. Now, while the court may be excluding some of the information that may be excluded may actually be considered Brady information because of the fact it's contrary to what they previously provided in their statements to police officers, in their statements to CPS, and in their statements in the protective order hearing. As the court is well aware, giving contradictory statements multiple times, that is a defense, and that is a valid defense available to my client when he's looking at these types of charges. At this time, with this information being given at this late notice, we have not had the opportunity to go through everything for him to be able to provide me his side of the story of what they've been given, or what the state has given to me. And as the court is well aware, this is why this court has multiple settings in order to make sure that discovery has been complied with. That is why we have to sign the discovery acknowledgement. It is very akin to what the court was afraid of yesterday with the fact of the first chair, the attorney of record, possibly having to step out of the case. We're looking at a situation that's going to come back on appeal because my client has not fully prepared given this new information with this tardy disclosure. So I'd ask for the court to grant my motion for continuance, and so we can continue preparing for this trial.
All right, so Ms. Gonzalez, are you the attorney of record on this case?
I am not the attorney of record. Ms. Franklin is the attorney of record. However, I'm sitting as co-counsel for her, with her.
And have you signed on and filed a notice of co-counsel?
I can, Your Honor. I have not done that yet.
You have not. And so the court doesn't have technically and legally, the motion for continuance, technically and legally, the motion for continuance, the motion to dismiss for lack of due diligence and violation of constitutional rights should not be something the court should have heard because you're not the attorney of record. But the court is hearing that. Just one moment, please. All right, motion for continuance is denied. Is there anything else from either side?
Nothing from the state, Your Honor.
Yes, Your Honor. In that case, I would ask orally for a motion for mistrial.
All right, that's denied. And the court will note for the record that defense counsel is not the counsel of record. All right, let's bring the jurors in.
Your Honor, one clarification. We actually did clarify that issue yesterday on the record orally when we handled the issue of Ms. Franklin having to possibly step out yesterday. We put all this information with me being appearing on the record for Mr. Scott in this case on the record yesterday.
All right, my understanding is that who would be appearing on the record would be if Ms. Franklin could not continue, it would be Mr. Archer. Is that was his last name, Archer?
Mr. Archer would be sitting with me, but I was going to be taking lead on the case.
All right, let's bring the jurors in if they're ready. Oh, sure.
If they're not.
We're ready.
All right, for the jury.
All right, everyone, please be seated.
Your Honor, briefly, may we approach?
Yes, I believe I'm aware of the issue.
Okay.
And so that will be taken care of.
Okay.
All right. Oh, come forward. I'll tell you.
Oh, my God.
All right, ladies and gentlemen of the jury, you all received an oath when you were downstairs, but now I'm going to give you an oath for this specific case. And I do realize that there are more of you than there should be. There should be one less person And I believe that's you, sir. So I'll allow you no, not you. I know you, no, it's not you. It's the person sitting next to you. So the person who's sitting next to you, Deputy Laura, if you can let him know he was excused from yesterday. All right. So if you want to escort, yes. Yes, yes. You were excused from yesterday. But thanks for coming back. No, you're fine. All right, so ladies and gentlemen, if you could raise your right hand for me, please. Do you and each of you solemnly swear or affirm in the case of the state of Texas against Mr. Scott, you will a true verdict render according to the law and the evidence, so help you God? All right, you can lower your hand. All right, state.
In the name and by authority of the state of Texas, the grand jury of Bexar County, state of Texas, duly organized and paneled and sworn as such at the November term AD 2020 of the 227th Judicial District Court of said county. In said court at said term do present in and to said court that in the court and state aforesaid and anterior to the presentment of this indictment on or about the 20th day of June 2022. MARCELLENO Scott, aka Scott Marcellino, hereinafter referred to as defendant, did then and there intentionally, knowingly, or recklessly cause bodily injury to Ashley Myers, a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship by pushing the complainant with the hand of the defendant, grabbing the complainant with the hand of the defendant, and holding the complainant down with the hand of the defendant. And on or about the 27th day of June 2022, the defendant did then and there intentionally, knowingly, or recklessly cause bodily injury to Ashley Myers, a member of the defendant's family, household, or a person with whom the defendant has or has had a dating relationship by grabbing the complainant with the hand of the defendant, tackling the complainant with the body of the defendant, and holding the complainant down with the hand of the defendant, and said conduct by the defendant occurred during a period that was 12 months or less in duration.
How do you plead to that?
Not guilty.
All right, you may be seated. State, are you ready to proceed with opening statements?
Yes, Your Honor.
You may proceed.
Good afternoon. I didn't get to speak with you yesterday, but as you know, this is a case involving domestic violence. Domestic violence happens frequently. We talked about you and Ruben talked about the reasons why it is important. In this case, you'll learn that Ashley Myers is the alleged victim in our case. She was in a relationship with the defendant, MARCELLENO Scott. They share one child together. However, they shared a household with multiple on both sides. They have been together for a while. Let's say live in multiple geographic locations. And like most couples, they would argue over money, jealousy, over multiple things. However, the defendant would escalate those things. Yeah. Get in Ashley's face. And you'll hear that the arguments would get messy, pushing, shoving. But it was mostly kept behind closed doors, away from the kids. However, in 2022, which is the date range that we're looking at, there's two incidences that you will specifically hear about. June 20th of 2022 is an incident between Ashley and the defendant. The defendant gets angry, grabs her, scratches her. We have pictures of the increase today. And then a week later, June 27th, you'll hear about another argument. And unlike the first one that you'll hear about, we do have a witness. We have a child. Because by this point, he's showing his aggressive side in front of the children. And you'll hear from Destiny, that's Ashton's daughter. You'll hear from her how he watched how, as this defendant, put his hands around her mom's neck, that she was terrified. And police came out. We talked a lot about one witness, this happens behind closed doors. And for one of the incidents, that is true. But you'll see Destiny on the stand, you'll see Ashley. And you'll be able to tell from their body language how this is affecting them. And how fearful they are. And once you hear from their accounts, and you hear how he is behind closed doors, we will ask you your other answer.
All right, defense.
Good afternoon, ladies and gentlemen. You are going to hear a lot about what's going on behind closed doors. I expect later today and possibly tomorrow, you're going to hear about not only the actions of my client, but why my client did the actions he did. And that he is not the only person behind closed doors that is escalating the tensions and situation between him and Ashley. I expect when you guys hear all of the evidence, you're not going to just hear two sides of the story. You're not going to just hear three sides of the story from a witness, an alleged witness of one of the alleged offenses. But you're going to hear multiple stories, multiple versions of the same actions of my client that are going to be coming from the state's two witnesses. That's going to be playing into the credibility of the witnesses of what we were discussing yesterday so long and talking about it so much, because it is so important for a juror, for you that were not in the house, that were not there and saw for your own eyes, to be able to make a determination of whether or not the state proves every single element beyond a reasonable doubt. Hearing those different versions, hearing about Ashley's action and how she escalates the situation and what she is doing in this home, we hope you find my client not guilty. Thank you.
All right, state, call your first witness.
The state calls Destiny Bolden. Oh.
Yes. All right, if you'll take a seat. Can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up so the jurors can hear and so that the court reporter can hear. Can you state your name for the record?
Destiny Bolden.
All right, state.
Good afternoon, Destiny. How old are you?
13,
And what grade would that put you in?
7.
7th grade?
Yes.
How many brothers and sisters do you have?
5,
5.
4 sisters and 1.
Where do you fall as the oldest or youngest?
The 3rd oldest.
You're the 3rd oldest.
Yeah, because I have twins, but like I was born first.
You have a twin? So is it a twin sister?
Yes.
You're right in the middle. Kind of. Who's your mom?
Ashley Myers.
Ashley Myers. And who's your dad?
Harold Bolden.
Do you know Marcellino Scott? Who is Marcellino Scott to you? How do you know him?
My mom like dating him.
Your mom dated him?
Yes.
Did he ever live with you?
Yes.
How long did he live with you?
I'm not sure, but like a while.
A while. Do you remember what grade you were in when he started living with y'all?
I think it was kindergarten or first grade.
Okay, so you were young.
Yes.
Okay. And June 2022, you were 12, right? Okay, and so you would have been going into the 6th grade. Okay, so from the time you were like kindergarten or 1st grade up until like your 5th grade year, you lived with y'all. Okay. What locations did y'all live in during that time?
Louisiana, Beaumont, now San Antonio.
Okay. How long have you lived in San Antonio?
Like a year and a half or 2 years.
Okay. Do you have any siblings who whose father is Mr. Scott?
Yes, one. My little sister,
Little sister, what's her name?
Dakota Scott.
And I think I skipped this. Do you see Mr. Scott in the courtroom today?
Yes.
Can you look at him and identify him by an article of clothing?
A light blue. I think light blue.
Okay. I'll ask the record to reflect that she has identified the defendant, Marcellino Scott. Now, the summer of 2022, where were you living?
San Antonio.
Okay. Here, so in Bexar County,
Yes.
were you living in a house or an apartment?
House.
How many bedrooms did that house have?
4.
Did you have your own room?
No, I share with my 2 sisters.
What 2 sisters did you share a room with?
One of the youngest ones and my twin sister.
Okay. Can you tell me who lived in the other 3 bedrooms?
My sister, my older sister had her own room, and my brother had his own, and my mom had her.
Okay. And where would Mr. Scott stay?
And with my mom in her room.
And where was Dakota?
Sometimes she'll be with us, and sometimes she'll sleep.
Oh, okay. Did Mr. Scott have any children other than Dakota?
Yes.
Would they ever stay with you?
Like one time.
And who was that?
One Scott,
Is she older or younger?
older,
You know how old she is?
probably like 19 now. How much?
Did you get along with Mr. Scott before 2022? Did you get along with Mr. Scott?
Kind of. Yeah, kind of. Not really.
Okay, can you help the jury understand what you mean by not really?
So, like, I guess he'd always get like mad at me and stuff. But I know I did things. So, yeah.
It just seemed like, he barely liked me, because after that one.
What kind of things would he get mad at you for?
I don't remember.
Okay. Did you ever see him get mad at your mom?
Yes,
How many times?
a lot.
Um, How did you know that when he was mad?
He just yell and make angry faces at me.
What would his face look like when he was angry?
What's your objection?
This goes to the exclusion of the previous information that was not tendered.
Your Honor, I would argue it's contextual.
All right, that objection will be sustained.
Okay, so, do you remember, an incident in June of 2022?
Yes,
okay. On June 27th of 2022. Do you remember an incident where police were called out to your home?
yes,
Do you remember about what time of day it was?
like evening, afternoon.
Over the summer, did you stay at home during the day or did somebody watch you somewhere else?
Oh, I don't understand.
I'm sorry?
I don't understand.
During the summer when you weren't in school, would you stay home?
Oh, yes,
Okay. And what time of day did you say you remember this happening?
like afternoon.
Afternoon? Okay. And who, before police came out, who was present in the house?
My mom, my little sister, and my,
And your little sister is Dakota?
yes,
Okay. Where were your other siblings?
they were by their like fathers and stuff for something, and I'm on the other side.
Okay. And when you say Mark, who are you talking about?
What do you mean?
So Marcelino Scott is the defendant that you identified. Is that who you refer to as Mark? Do you remember Mark and your mom having an argument that day?
No.
What do you remember about that day?
So I was getting like my hair washed, and then my mom was just about to blow dry it, but he walked in the room and asked for the keys. And my mom said no, so he took the Wi-Fi boxes and stuff. And I think he threw it, but then my mom had yelled a curse word, and then he thought it was disrespectful and stuff. So he had like got closer because she was behind me. So yeah, and he was just yelling beside me. So I got scared and my water bottle flew and hit him. And it was like a reflex, but I didn't mean to.
Yes,
It's really, it is kind of hard. Your Honor, may I approach the witness?
yes.
Okay. It does it. I'm sorry. I have no control over it. Just because it's a little hard to hear you. Can you, like, talk a little bit?
Hi.
Okay, that's fine. Thank you. Okay, so you said your mom was about to wash your hair?
Oh, she already did. She was gonna go dry.
Okay. And where was Mr. Scott when she was, I guess, washing your hair? Was he home?
Yeah, I think he was in the other room.
Okay. And so where were you sitting? I guess, which room were you in when she was trying to dry your hair?
My brother's room.
And where were you sitting? I'm assuming sitting with your mom.
On the bed, but it was like a side, and I was in front of her on the chair.
Okay. What kind of chair was it?
It was like one of my sister's little chairs.
Was it like a wooden chair,
Yeah.
computer chair, a sofa?
I think it was wooden. I'm not sure.
It was a chair.
Yeah.
And how long does it take your mom to dry your hair?
20 minutes.
And you said that Mr. Scott came in the room?
Yes.
You know why he came in the room?
For the keys.
Keys to what?
The check.
Was that his truck? Or your mom's truck?
I think his name's in it, but it was my mom's, but his name's like, she said,
Okay. Did he say where he wanted to go?
no,
And so when he first entered the room, was he calm or was he angry when he entered? So what was it that made him angry?
she said no.
She said that he could not have the keys. And so where was he standing?
By the door.
He was by the door. How close was that to your mom?
It wasn't close.
Okay. So you said it wasn't close at all?
Yeah, it wasn't.
Okay. How big was your brother's bedroom?
It's not like big, kind of small.
Okay. Let's see, this is kind of a big courtroom, right?
Yeah.
Okay. So from where I'm sitting, the edge of my table here, to say the wall, is that,
No, it was smaller.
it was smaller than that? Okay, so it was a good distance, but it was a pretty small room.
Yes.
And so what happened when your mom said no?
Oh, that's when he grabbed the Wi-Fi boxes in her purse.
Okay, where were the Wi-Fi boxes?
They were like on his bed stand, because he had like a stand, and it was like shelves and stuff, and he just grabbed them.
Was this in your brother's room?
Yeah.
So when you say he had it, you meant your brother? Or did the defendant keep them there?
My mom kept them. Like,
Oh, okay.
stuff.
Okay. So there were Wi-Fi boxes next to your brother's nightstand in your brother's room.
Yes.
And do you know why he grabbed the Wi-Fi boxes?
No, Objection, Your Honor, speculation.
Sustained.
Were the Wi-Fi boxes attached to the wall or were they being
No,
stored?
they were in the box.
They were in the box. Okay. So he grabbed the Wi-Fi box and what else?
My mom's purse.
The purse. Okay. Where was your mom's purse?
I think he was on the bed.
And then what did he do? Once he grabbed the Wi-Fi box and your mom's purse.
Might have dropped it or threw it once she had yelled the word.
Okay. So she yelled at him
Yes.
and was she still sitting down?
Yes.
And was he standing, sitting, or something different?
Stand.
So what did he do when she yelled at him?
What did he do? Oh,
What did he do?
he like walked close.
Okay. And how close was he to you and your mom?
Like right here close. Yeah.
And were you and your mom sitting down?
Yes.
And was he still standing?
Yes.
What did he say, if anything?
I don't know, it's just young.
A lot of yelling? Okay. And then what happened?
Oh, that's when I learned about it.
So you had a water bottle?
Yeah, the whole time. I didn't, like, it was with me, because I was drinking it. Yeah, but after that, that's when it choked me. Choked my mom after that.
What did you do with the water bottle?
Mm.
How did the water bottle hit him?
Oh, because when he got close to me, I jumped.
And where did it hit him? It hit his face? Did it have water in it or was it empty?
Yeah,
It still had water in it? Did he say anything when the water bottle hit his face?
no, it's in the face.
What kind of face did he make?
I see it's in there.
Okay. And what about his face led you to believe that he was mad?
This is eyes.
And what did he do with his eyes?
He just get big.
His eyes would get big. And how did you feel when his eyes got big?
Like scared.
And you said you had jumped up. Was your mom standing up?
No,
Your mom was still seated?
yes.
And then what did he do?
Wait, after he jumped me?
Okay, so you hit him with the, or he got hit with the water bottle. Okay. And I'm trying to help the jury understand how it went from the water bottle to, you said he was choking your mom.
Yeah, I think he probably got mad about that. So yeah, like just started choking me.
And when you say choking, what do you mean?
Like just two hands on me.
So he used two hands, and where did he put his hands?
Around here.
And when he put his hands around her neck, did she stay in the same spot or did she go somewhere else?
Well, she had her to lay down, so I guess she was laying down.
Okay. So did she stand up on her own?
Yeah, I think because after he's out, yeah.
Okay, well, after he got off. When he got hit with the water bottle, and then you said he put his hands around your mom's neck. Was she still in the seat when he did that, or
Oh, she was laying down.
she was on the bed? Okay. When did she lay down on the bed?
I think he might have put her down. I'm not sure because I only saw the part when he started.
Okay. And what was your mom doing while he had his hands around her neck?
Like her hands just like on his face, trying to
On her face, I'm sorry.
yeah, on her face, on his face. His hands was-
Okay. When he had his hands around her neck, where were her hands?
like on his face, trying to get him off.
Okay, so she was she like using force against him, trying to get him off?
I think so.
Okay. Was she making any noise?
No,
Was he making any noise?
no,
Did you notice anything about your mom's eyes?
yeah, they were closing.
When you say they were closing, did it look like, was it she was closing them to relax, or in what way were her eyes closing?
Like he was choking her too tight, so it made her eyes closed. Like I don't want to see it. Unconscious.
Unconscious?
I don't know, like something like that when you like close my neck too hard or something.
How were you feeling when that was happening?
I'm scared. Cause I didn't know what to do.
How long did he have his hands on your mom's neck?
20 seconds.
And what did you do?
I just like ran out the room and get my phone. I was gonna like record or call the cops, but he had it down.
Do you remember how your mom was right after you let go of her?
No, I was in the other room.
So you ran out of the room. Who ended up calling the police?
My mom.
And how quickly did the police get there?
I don't know.
Do you remember Mr. Scott saying anything while it was happening?
I don't remember the words, exact words.
Do you remember what he was, how loud he was saying things?
Yeah. Wow.
Were they, who was he talking to loudly?
My mom.
Was he talking or was he yelling?
And talking. Well, sometimes it was talking to me.
And this was while he had his hands on her neck?
No, I thought we were when we got out.
When he got off, okay. When he had his hands on her neck, did he say anything?
No, not that.
Um. Where was Dakota when this was happening?
Next to me.
And how old is Dakota today?
5.
So she was 4
Yes.
when that happened?
Yes.
What was Dakota doing?
Like just crying.
Did she stay in the room?
No, she was outside the room.
And then when police came, did you speak to police that day?
Yes.
I'll pass the witness.
Defense.
Thank you. Destiny, my name's Jessica Gonzalez. We've never met before, but I've reviewed some of your statements and I've been sitting here listening to your testimony, and so I'm gonna ask you some questions, okay? If you don't understand any of my questions or you can't hear me, just let me know and I'll ask it again, okay? All right. So you told the prosecutor, Ms. Mitchell, that you were 13 years old. Are you 13 years old now, or were you 13 years old back then?
No, I was 12.
Okay, so you're 12 years old. Now, how many times have you told this story to other people? Can you think? Would it help you if I listed some of the people and you said if that happens? Okay, so when the police officers were called, you spoke to a police officer that day, right?
Yes.
Okay. And you gave them part of the story, right?
Yeah, they didn't really ask.
Okay, but you told them that you were there and you told them just some of the details from what you told us today, right?
Yes.
All right. And after the police were there, you also talked to Child Protective Services, CPS. Do you remember that?
No.
You don't remember speaking to CPS?
No.
Okay. What about these prosecutors? Have you ever spoken to the prosecutors about your story?
Yes.
Okay. When was the last time you spoke to them about it?
Remember yesterday?
Yesterday. And then during all this time, or you still live with your mom, right?
Yes.
Have you spoken to your mom about what happened on the 27th?
Recently?
Recently or any time since last year? Have you guys talked about that day?
Not really.
Not really, but you have, right? Yes.
Yes.
Okay. May I approach you? Honor?
Yes.
Destiny, you said. Destiny, you said you're in the 7th grade, right?
Yes.
But you said that you don't remember talking to CPS?
Yeah.
Okay, I'm gonna hand you a document. I don't want you to read it out loud, okay? I just want you to read it to yourself and see if this helps you remember speaking to CPS, okay? Start right here. And you can go over to this paragraph right here, okay? I'm gonna go sit down. Just let me know when you're ready. Okay, and when you spoke to the prosecutors yesterday, did you speak, did they have you read your statement from the police report when you gave to the officers? Did they let you read that?
No.
Okay, would you like to read that today too? I'm sorry, I didn't hear you.
Well, yeah.
Okay.
Your Honor, I'd object to there doesn't seem to be a need to refresh recollection, and this is not her statement. This is an offense report that she's.
All right, well, what's the question of the witness?
If she remembers what she said to the officers specifically.
All right. Do you remember what you said to the officers specifically is the question that's being asked?
Not really.
All right, so what's your next question?
My next question is may I approach to refresh your memory?
Well, I mean, what question do you have of her? She's saying she doesn't remember specifically what she said to the officers. So what question do you have? And then if she doesn't remember and needs to refresh, then she can refresh.
So Destiny, you've spoken to several different people about what you remember on that day, right?
Yes.
And you've also just told us that you've also talked to your mom since that day happened, right? From what I've shown you, do you see how there's differences in your story?
No. I also got something.
You forgot some of the things, right?
No.
And it, from what you remember, it was a very scary incident for you, right? You were 12 years old.
Yes.
Okay. Could that also be playing into why you changed some of the details?
I don't understand.
Object to speculation.
All right, that'll be overruled. She said she doesn't understand your question.
Okay, thank you. Emma. So I was just saying, it was a very scary time for you, right?
Yes.
And some of the details have changed in your story every time you've told it, right?
Not really.
Okay, my approach now, Your Honor?
Well, what details are you speaking of, counsel?
So you told this jury that my client walked into the room and that he was calm. Isn't that correct?
Yeah.
Okay. And when he came in there, you stated he was trying to get his key back. Isn't that correct? You said the truck, the truck key?
Yes.
Okay. And you just told the jury that that was in his name, correct?
Yes.
Okay. And your mother was the one that actually yelled at him first, right?
Yeah.
Okay. Now, when that happened, is that when you started to get scared and about what was going on?
Yeah. I just got scared as soon as he came in there.
So you got, I mean, so you were scared just with him walking in the door, even though he came in there calmly, right?
Yeah, because he's always mad about something, so I'm scared.
So, I mean. Now, were you present when your mother had maced him?
Yes.
Okay, how many times has your mother maced Mark?
One time.
You remember it as one time?
That's the only time I was there for that one time.
Okay, and was that the incident that happened last year? Or was it the incident that happened a couple days before what happened on the 27th?
It was like way before that, so.
Okay, so like either the one last year or the other one that was before that one?
I don't.
Well, let me ask you this. Did you know that your mother has maced Mark 3 times?
No.
Okay, so you didn't know it was 3 times.
No.
You only know about the one time when you were there.
Yes.
Okay. So you just testified that he came in the room, he was asking for his truck key, and your mother was yelling at him, right? Do you need a moment?
Yes.
All right, ladies and gentlemen, we're going to take a short recess, okay? All right, so I'm going to have you all back here at 4:10. You've heard some evidence in this case. You're not allowed to discuss it amongst yourself. You're not allowed to do any research in this case. You're not allowed to start deliberating. Everything that you need to know about this case has come from inside this courtroom. Does everyone understand? All right, everyone, please rise.
Right?
You ready?
Yes.
All right, everyone. I'm calling 2022 CR 10756, State of Texas versus Marcelleno Scott. Could I have parties announced for the record for the state?
Ruben Herrera for the state.
Jessica Gonzalez from Mr. Scott.
Are you
Tracy
Frank
Franklin from
Oh, no problem. I'm sorry about that. Repronounce, I'm sorry, reannounce.
Tracy Franklin for Mr. Scott.
Are you Mr. Scott?
Yes, I am.
All right, everyone can remain seated. Defense, have you received all the discovery? Did you review it with your client?
Yes, Your Honor. However, we signed the discovery acknowledgement yesterday. Sorry. We do have the one addition, which would be the Brady memo that was emailed to me last night.
The court then will find that the state is in compliance with discovery. Mr. Scott, have you reviewed the document entitled Application for Deferred Adjudication of Community Supervision with your attorneys? Did you understand it and did you sign it?
Yes.
And have you reviewed the indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding as to count 2, the lesser included charge of assault, bodily injury, married cohabitation.
Any objection?
No objections.
All right. Mr. Marcelleno, have you reviewed the document entitled Court's Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation as a Class A misdemeanor? The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the document that includes the plea bargain page?
Yes.
According to the plea bargain, the state is proceeding on count 2 of the indictment. They're proceeding on the lesser included offense of assault, bodily injury, married cohabitation. They're recommending deferred adjudication and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of your plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
And not exactly. We did want to, he understands that affirmative finding of family violence will be made in this case.
Yes.
However, he is not in agreement, and I did have information or reading of statutes to put on the record regarding that, but he does understand it will be made, and those are the consequences of affirmative finding of family violence and this plea.
Okay, I don't understand. Did I say something different or?
Well, you asked if that was our entire agreement, and that's what I'm
Yes.
saying is that it's not exactly.
All right, do you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
And do you understand that the collateral consequence of an affirmative finding of family violence is also that you will not be allowed to be designated as primary custodial parent?
Yes.
All right, state, is that the agreement?
Yes, it is, Your Honor.
Defense, is that the agreement? Defense?
Again, Your Honor.
Here's the thing, I'm saying that because I don't want people to say, I had no idea that with an affirmative finding of family violence, I can't own a weapon. With an affirmative finding of family violence, I'm on the civil side, I'm trying to get custody of my children, and they're telling me I have an affirmative finding of family violence. So those are consequences of it. And so, Mr. Scott, do you understand with an affirmative finding of family violence, if I review the evidence that's admitted to the court, if I review it and I determine that this involved family violence, that I will find an affirmative finding of family violence?
Yes.
All right, did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes.
Counsel, have there been any such motions?
Yes, Your Honor.
All right, outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There'll be no contact with Ashley Myers and Destiny Bolden. That's MEYERS and BOLDIN in the BIPP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense of assault, bodily injury, married cohabitation. How do you plead? Guilty, not guilty, or no contest?
No content.
State any evidence?
State offers States Exhibit 1 and all of its attachments.
No
Any
objection.
objection?
No objections.
All right, did you review the document entitled waiving consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witness statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We can, Your Honor.
Anything you wish to say on behalf of your client?
Yes, I think the better way for me to answer the court's earlier questions with regards to the affirmative finding of family violence is that in our plea agreement is that it was my understanding in talking to the prosecutors about the case is that we would be going open on that affirmative finding. I would present my arguments to the court, but we also did, by we, I mean my client and I, Mr. Scott, did understand that the court will be making the affirmative finding of family violence.
All right, I'll hear your argument.
Thank you, Your Honor. With regard to the affirmative finding of family violence, I would ask all to be able to look at Article 42.013 of the Texas Code of Criminal Procedure. This is speaking directly to the finding of family violence. It does state at the end of the paragraph that the court shall make the affirmative finding of fact and enter the affirmative finding of fact in the judgment of the case. The next argument in support of asking the court not to make this finding is going to be under Article 42.01, which is specifically describing in the Texas Code of Criminal Procedure the meaning of the word judgment. Section 1 states a judgment is the written declaration of the court signed by the trial judge and entered of record showing the conviction or acquittal of the defendant. With those two words, Your Honor, put in those two articles put together, we are saying that with my client's case being deferred and he's going to be placed on deferred adjudication, that being placed on deferred adjudication and looking at all of the orders that come from the court, it is actually an order of deferred adjudication, meaning that he will not be found guilty, which is required for a conviction at this time. Now, of course, if he comes back from the court before the court on a motion to revoke, and the court does revoke his community supervision and does make a finding that he is guilty of this offense, that would be a conviction. And at that time, an affirmative finding of family violence would be appropriate. But while he is on deferred adjudication, and if he completes it successfully, that an affirmative finding of family violence would not be appropriate as defined by by Chapter 42 of the Texas Code of Criminal Procedure.
All right, state.
Your Honor, it's the state's position that because there was a family relationship between the defendant as well as the complaining witness, and that they had a previous dating relationship, And while they were no longer dating at the time of the incidences, or at the time of the incident, they were cohabitating in the same household, that satisfies the statute in indicating that there was a family or household relationship, or a married cohabitate relationship, and that the affirmative finding be enforced.
All right.
And Your Honor, just to respond to the state, we have no objection to that statement and that there is that relationship. We are strictly talking about the judgment and conviction language of the Texas Code of Criminal Procedure.
All right. This is what the court will do. The court will sentence you to 2 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Ashley Myers and Destiny Bolden, the BIP course, regular reporting by Zoom or in person, proof of employment within 30 days. There's to be no employment as a home health care provider with minors, regular UAs, 80 hours community service restitution. Those hours will be satisfied once you've completed parenting classes, and that will be with Triple P. Field visits one time per month for 2 months. Probation, if there's no issue with the field visits, then those can be discontinued. Probation, is there anything else that's needed?
No, Your Honor.
Mr. Scott, is there anything else you need from the court to be successful?
No more. No, Your Honor.
All right, Mr. Scott, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Mr. Scott, good luck to you.
Thank you.
All right.
But Your Honor, one other thing, and I don't know if it needs to be on the record, but my client did inform me that he does take CBD oil. So we would be asking that the first initial UA be actually get the levels of it. So that way we have as a baseline to show that he has stopped using any substances if it's going down.
All right. So, Ms. Abrams, if you can make sure that they test him for levels.
Okay.
All right, is there anything else from either side?
Your Honor, we do have victim impact to do.
All right. All right,
Where do we want to? No.
Mr. Scott, in the 187, I always require that everyone treats everybody with respect. So when victim impact